Dear students, I welcome you to yet another lecture on corporate law. The topic of discussion for today is the appointment and qualification of directors. In today's lecture, we shall discuss certain important provisions relating to directors. A company is an artificial person in the eyes of law. It has no physical existence. So, there has to be some agency of humans to control and manage it. People who do so and constitute an agency are known as the board of directors. They run the affairs and management of the company. Thus, a director is a professional person hired by the company to manage and run its business. Dear students, we now talk about the maximum and the minimum number of directors in a company. Section 149, Clause 1 of the Companies Act 2013 provides that every company shall have a minimum number of 3 directors in case of a public company, 2 directors in case of a private company, and 1 director in the case of a one-person company. A company can appoint a maximum of 15 directors. If the company wants to appoint more than 15 directors, it can do so after passing a special resolution in the general meeting. Pertinently, approval of the central government is not required. Number of directorships in a company. A person can hold a maximum number of 20 directorships, including alternate directorships. Further, number of directorships in public companies or private companies that are either holding or subsidiary company of a public company shall be limited to 10. If the members of a company are desirous of further restricting this limit, they have to pass a special resolution for that purpose. Dear students, we now try and understand the residence of a director in India. Under Section 149, Clause 3 of the Companies Act, it is incumbent upon every company to have at least one resident director. That is, every company shall have at least one director who has stayed in India for a total period of not less than 182 days in the previous calendar year. Dear students, now we shall look at women directors. There shall be certain class of companies who shall have at least one woman director. These are every listed company, every other public company having number 1, paid up share capital of rupees 100 crore or more, number 2, turnover of 300 crore or more. Dear students, we now look at the appointment and qualification of independent directors. An independent director means a director other than a managing director or a whole-time director or a nominee director, who does not have any material or pecuniary relationship with the company or its directors. Every listed public company shall have at least 1/3 of the total number of directors as independent directors. The fraction is to be rounded off to 1. The central government has prescribed a certain class of companies to have at least 2 directors as independent directors. Under Rule 4 of the Companies Appointment and Qualification of Directors Rules 2014, these are public companies having number 1, paid up share capital of rupees 10 crore or more, number 2, turnover of rupees 100 crore or more, number 3, or in aggregate outstanding loans or borrowings or debentures or deposits exceeding rupees 50 crore or more. The criteria for independent directors are prescribed under Section 149, Clause 6 of the Companies Act. It provides that an independent director shall be a person A, who in the opinion of the board is a person of integrity and possesses relevant expertise and experience. B, who is or was not a promoter of the company or its holding or subsidiary or associate company, who is not related to the promoters or directors in the company, its holding company, its subsidiary company or associate company, who has or had no pecuniary relationship with the company, its holding or subsidiary or associate company or their promoters or directors during the two immediately preceding financial years or during the current financial year, none of whose relatives has or had pecuniary relationship or transaction with the company, its holding company or subsidiary company or associate company or their promoters or directors amounting to 2% or more of its gross turnover or total income or 50 lakh rupees or such higher amount as may be prescribed, whichever is lower during the two immediately preceding financial years or during the current financial year. E. Who neither himself nor any of his relatives, number 1, holds or has held the position of a key managerial personnel or is or has been an employee of the company or its holding or subsidiary or associate company in any of the 3 financial years immediately preceding the financial year in which he is proposed to be appointed. Number 2, is or has been an employee or a proprietor or a partner in any of the 3 financial years immediately preceding the financial year in which he is proposed to be appointed, of a firm of auditors or company secretaries in practice or cost auditors of the company or its holding company or its subsidiary company or associate company. Any legal or consulting firm that has or had any transaction with the company, its holding company or subsidiary company or associate company amounting to 10% or more of the gross turnover of such firm. Number 3, holds together with his relatives 2% or more of the total voting power of the company. Or number 4, is a chief executive or director by whatever name called of any non-profit organization that receives 25% or more of its receipts from the company, any of its promoters, directors or its holding company, its subsidiary company or associate company, or that holds 2% or more of the total voting power of the company. Or lastly, who possesses such other qualifications as may be prescribed. Dear students, we now look at the declaration that has to be made by an independent director. Every independent director shall, at the first meeting of the board in which he participates as a director, give a declaration that he meets the criteria of independence. Thereafter, at the first meeting of the board in every financial year or whenever there is any change in the circumstances which may affect his status as an independent director, he has to give a declaration that he meets the criteria of independence. Dear students, we now look at the remuneration of an independent director. As per section 149, clause 9 of the Companies Act, an independent director shall not be entitled to any stock option. He may receive remuneration by way of sitting fee, reimbursement of expenses incurred for participation in the board and other committee meetings, and profit-related commission as may be approved by the members as provided under section 197, clause 5 of the Companies Act. Term and reappointment of an independent director. Subject to the provisions of Section 152, an independent director shall hold office for a term up to 5 consecutive years on the board of a company. He shall be eligible for reappointment only on the passing of a special resolution by the company and disclosure of such appointment in the board's report. Pertinently, no independent director shall hold office for more than 2 consecutive terms, but such independent director shall be eligible for appointment after the expiration of 3 years of ceasing to become an independent director, provided that an independent director shall not, during the said period of 3 years, be appointed in or be associated with the company in any other capacity, either directly or indirectly. Dear students, we now look at the liability of an independent director, which is provided in Section 149, Clause 12. An independent director or a non-executive director not being the promoter or key managerial personnel shall be held liable only in respect of such acts of omission or commission by a company which had occurred with his knowledge, attributable through the board's processes and with his consent or connivance, or where he had not acted diligently. Dear students, now we look at the manner of selection of the independent directors and the maintenance of a data bank of independent directors. An independent director may be selected from a data bank of persons who are eligible and willing to act as independent directors. The data bank shall be maintained by any agency such as an institute, a body, or an association authorized by the central government. Such agency shall put the data bank of independent directors on the website of the Ministry of Corporate Affairs or any other notified website. However, responsibility of exercising due diligence before selecting a person from the data bank as an independent director shall lie with the company making such appointment. The appointment of the independent director shall be approved by the company in its general meeting. Dear students, we now look at the directors which is to be elected by small shareholders. Section 151 of the Act provides that every listed company may have one director elected by small shareholders. For the purpose of this section, small shareholder means a shareholder holding shares of nominal value of not more than 20,000 rupees or such other sum as may be prescribed. A listed company may, upon notice of not less than 1,000 small shareholders or 1/10 of the total number of such shareholders, whichever is lower, have a small shareholders director elected by the small shareholders. Pertinently, a listed company may opt to have a director representing small shareholders suo motu. Sub-Rule 2 of Rule 7 of the Company's Appointment and Qualification of Directors Rules 2014 states that small shareholders intending to propose a person as a candidate for the post of small shareholders director shall leave a notice of their intention with the company at least 14 days before the meeting under their signatures, specifying the name, addresses, shares held and the folio number of the person whose name is being proposed for the post of a director and of the small shareholders who are proposing such person for the post of director. provided that if the person being proposed does not hold any shares in the company, the details of the shares held and the folio number need not be specified in the notice. A person appointed as a small shareholder's director shall vacate the office if the director stands disqualified as per the criteria specified in section 164. The office of the director becomes vacant in pursuance of section 167. Lastly, the director ceases to be an independent director as per the criteria of independence provided in subsection 6 of section 149. A person cannot be appointed as a small shareholder's director in more than 2 companies at the same time. Also, the second company in which he has been appointed shall not be in a business which is competing or is in conflict with the business of the first company. A small shareholder's director shall not, for a period of 3 years from the date on which he ceases to hold office as small shareholder's director in a company, be appointed in or be associated with such company in any other capacity, either directly or indirectly. It is important to remember that in contradistinction to independent directors, the Companies Act 2013 does not specify any qualifications or minimum industry experience criteria for the small shareholders' directors. There is no requirement for the candidate to be a small shareholder or even a shareholder of the concerned listed company. Dear students, we now look at the provisions which regulate the appointment of directors in a company. First, director. Ordinarily, the Articles of Association of a company name the first directors of the company. If they are not so named in the Articles of a company, then subscribers to the Memorandum of Association who are individuals shall be deemed to be the first directors of the company until the directors are duly appointed. In the case of a one-person company, any individual being a member shall be deemed to be its first director until the director or directors are duly appointed by the member in accordance with the provisions of section 152. Dear students, now we look at the general provisions relating to the appointment of directors. These are: number 1, except as provided in the Companies Act, every director shall be appointed by the company in its general meeting. Number 2, director identification number is mandatory for the appointment of directors in a company. Number 3, every person proposed to be appointed as a director shall furnish his director identification number and a declaration that he is not disqualified to become a director under the Companies Act. Number 4, a person appointed as a director shall not act as a director unless he gives his consent to hold the office as such a director, and such consent has been filed with the registrar within 30 days of his appointment. Now, dear students, we look at the various provisions relating to the retirement of directors. Articles of the company may provide the provisions relating to retirement of the directors. If the articles are silent, then not less than 2/3 of the total number of directors of a public company shall be persons whose period of office is liable to determination by retirement by rotation and eligible to be reappointed at the annual general meeting. At the annual general meeting of a public company, 1/3 of such of the directors for the time being as are liable to retire by rotation, or if their number is neither 3 nor a multiple of 3, then the number nearest to 1/3 shall retire from office. The directors to retire by rotation at every annual general meeting shall be those who have been longest in office since their last appointment. Further, independent directors shall not be included for the computation of total number of directors. Dear students, we now look at the appointment of additional directors in a company. The articles of association of a company may confer power on the board of directors to appoint additional directors. Such additional directors are eligible to hold office only up to the date of the next annual general meeting or the last date on which the annual general meeting should have been held, whichever is earlier. A person who fails to get appointed as a director in a general meeting cannot be appointed as an additional director. Dear students, now we look at the appointment of alternate directors. Section 161, Clause 2 of the Act has allowed certain things. These are, number 1, an alternate director can be appointed by the board of directors of a company if it is authorized by its articles or a resolution has been passed by the company in the general meeting. Number 2, alternate director can be appointed in place of a person who is absent for a period of not less than 3 months from India. Number 3, the person to be appointed as the alternate director shall be the person other than the person holding any alternate directorship for any other director in the company. Number 4, if it is proposed to appoint an alternate director in place of an independent director, then it must be ensured that the proposed appointee also satisfies the criteria laid down for independent directors. Number 5, an alternate director shall not hold office for a period longer than that permissible to the director in whose place he has been appointed, and shall vacate the office if and when the director in whose place he has been appointed returns to India. Number 6, if the term of office of the original director is determined before he so returns to India, any provision for the automatic reappointment of retiring directors in default of another appointment shall apply to the original and not to the alternate director. Dear students, we now look at the appointment of directors by nomination. Nominee director means a director nominated by any financial institution in pursuance of the provisions of any law for the time being in force or of any agreement, or appointed by any government or any other person to represent its interest. Subject to the Articles of Association of a company, the board may appoint any person as a director nominated by any institution in pursuance of the provisions of any law for the time being in force or of any agreement, or by the central government or the state government by virtue of its shareholding in a government company. Dear students, now we look at the disqualifications for the appointment of directors, which are given in section 164 of the Companies Act 2013. A person shall not be eligible for appointment as a director of a company if A, he is of unsound mind and stands so declared by a competent court. B, he is an undischarged insolvent. C, he has applied to be adjudicated as an insolvent and his application is pending. D, he has been convicted by a court of any offence, whether involving moral turpitude or otherwise, and sentenced in respect thereof to an imprisonment for not less than 6 months, and a period of 5 years have not elapsed from the date of expiry of the sentence. Provided that if a person has been convicted of any offence and sentenced in respect thereof to an imprisonment for a period of 7 years or more, he shall not be eligible to be appointed as a director in any company. Any order disqualifying him for appointment as a director has been passed by a court or a tribunal, and the order is in force. F. He has not paid any calls in respect of any shares of the company held by him, whether alone or jointly with others, and 6 months have elapsed from the last date fixed for the payment of the call. G. He has been convicted of the offence dealing with related party transactions under section 188 at any time during the last preceding 5 years. H. He has not complied with subsection 3 of section 152. No person who is or has been a director of a company which has not filed financial statements or annual returns for any continuous period of 3 financial years, or has failed to repay the deposits accepted by it, or pay interest thereon, or to redeem any debentures on the due date, or pay interest due thereon, or pay any dividend declared, and such failure to pay or redeem continues for 1 year or more, shall be eligible to be reappointed as a director of that company or appointed in another company for a period of 5 years from the date on which the said company fails to do so. Dear students, that is all with regard to today's lecture on the appointment and the qualification of directors. In today's lecture, we tried to understand the appointment of directors. We also tried to understand the disqualification of directors. We also tried to understand who are the independent directors of a company. That is all with regard to today's lecture. Hope you enjoyed the lecture. Stay blessed.